Good day to you, and welcome to another Paddocks Club video tutorial. This tutorial deals with a query raised by Karin Kutsi on the discussion forum recently, and I thought I gave her an answer, and I thought, that's not really going wide enough. We need to publicize this slightly more widely. And Karin's problem was that in a scheme that she managed, the trustees, who she thought considered themselves quite clever, had said that they would and could disconnect the water supply to various of the units that were in levy arrears. She had told them that this was illegal and it would just be a matter of time before people would take legal action against them, and that they might even be held personally responsible. But they weren't impressed. As far as they were concerned, their cleverness was, we'll turn off the water to the residential part of the unit and we'll leave them with some water in the garden, because that's good enough. While Karin was quite sure that disconnecting electricity is illegal in terms of the Electricity Act, she wanted something that she could give the trustees who are connecting water. So I did threatening to disconnect water. So I did a little bit of digging, and I came across the following. Firstly, the obligation to provide water is a constitutional obligation, and the people who have to provide water are the municipalities. In terms of Section 3.1 of the Water Services Act, everyone has a right of access to a basic water supply and basic sanitation. The Section 4.2 of that Act provides that the water provider must have publicly accessible conditions of supply that include details of how they might limit or discontinue the supply of water. And those conditions have to be fair and equitable. They have to provide reasonable notice of intention to limit or discontinue water. And unless, of course, other consumers would be prejudiced, there's an emergency situation, or the consumer has already interfered with a limited or discontinued service. Finally, any discontinuation or limitation must not result in a person being denied access to basic water services for non-payment, where that person is able to prove to the satisfaction of the relevant water services authority that he is in fact unable to pay for basic services. Now, we know that's very unlikely to happen in the context of sectional title scheme, but it gives the general picture. The most important thing is that sectional title bodies corporate are not water service providers. They have no right to interfere or cut off the supply of water to any part of a sectional title unit. People are, in terms of Regulation 3 of Government Notice 509 of 8th June 2001, which establishes compulsory national standards and measures to conserve water, entitled to a certain amount, and that is quantified as 25 litres of potable, that's drinkable water per day per person, or 6 kilolitres per household per month. Please be careful of this. Don't ever consider limiting or cutting off a supply of water to a sectional title resident. Thank you for joining me, and we are welcome to raise any questions in this regard in the discussion forum.